that.
And do you understand that the appointed counsels are trained in the practice of felony criminal law and trial practice?
Hard for me to tell.
Now, here's the thing. I'm asking you questions, and your answers to my questions are going to be appropriate.
Money, and what I did was verbally, what was like a what you, and that was enough to seeing her diving for cover and this other one hiding behind the chair. I'm like, what y'all jumping for? Like, whatever, man. Look, give me my money, man. Why you keep playing with me? With my phone in my hand and my wallet.
I found this case interesting from the very beginning because of the defendant. From arguing with his own lawyer, to choosing to represent himself, to the way he delivers his closing statement, the case really centers on his mindset and how he approaches everything happening around him. What makes it wild is what he's actually facing. This isn't a minor charge. It's aggravated robbery with habitual offender enhancements, meaning the consequences could be massive. Decades in prison, even life. And yet he moves through the courtroom with confidence, pushing back, talking over people, and clearly believing he can explain his way out of it. I left the witnesses out on purpose, because almost everything that matters shows up in closing arguments. And honestly, the full video would be hours long. In his closing, he leans hard on the idea that there was no theft, no weapon, and no intent, framing the situation as a misunderstanding that spiraled out of control. He also addresses how people perceive him, acknowledging that he can come across as harsh or intimidating, and tries to separate that from criminal intent. And the ending is what really makes this case worth watching. It doesn't happen often.
For the defense?
Leland McCray on behalf of Mr. Ross, who's standing in front of me.
All right, and Mr. Porter?
Yes, Your Honor.
And you're on this case as well, is that correct?
That's correct.
All right. And
Objection, Your Honor.
let me finish. Here's the thing. Let me finish. All right. And also, Mr. Porter, you're a second chair?
Yes, Your Honor.
All right. So, Mr. Ross, it's the court's understanding that you wish to proceed pro se. Is that correct?
It is correct.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Do.
All right. You can lower your hand, state your name for the record.
James Ross,
All right. How old are you?
43,
And what is your highest level of education that you've completed?
second year in college.
All right. Are you able to read, write, and understand English?
Yes.
Are you under the influence of any type of alcohol, drugs, or medication?
No.
Have you ever been treated for mental illness or any type of cognitive impairment?
No.
Do you understand why you're here today?
Do.
And why are you here today?
Being accused of aggravated robbery and attempt to defend myself against these charges.
All right. Do you understand that in felony cases, you have an absolute right to have an attorney?
I do.
And do you understand if you cannot afford an attorney will be appointed to you?
Understand that.
And you understand the attorneys that have been appointed to you are Leland McCray and Robert Porter as second chair. Do you understand?
I do understand that.
And do you understand that the appointed counsels are trained in the practice of felony criminal law and trial practice?
Hard for me to tell.
Now, here's the thing. I'm asking you questions, and your answers to my questions are going to be appropriate. We're not going to do this thing where we're saying disparaging things against each other. Do you understand?
Yeah.
So you understand that your attorneys are trained in felony criminal law.
Do.
And you understand that they're trained in trial practice.
Do.
And do you understand in order to be appointed to represent you, they have to have been approved for appointment levels at the level of first-degree felonies?
I do understand.
Okay. And have you discussed with your attorneys your request to represent yourself? Have you discussed with both attorneys that you wish to represent yourself?
I have, but before we get to that point, I gave him ample opportunity for, produce any type of defense for these charges, and he's done nothing. He's not.
All right, just a moment. I'm going to continue asking my questions and just, give me an answer. So it's my understanding, and we're back on the record, it's my understanding that you are asking to represent yourself. Is that correct?
That's correct.
Okay. Did you inform your attorneys that you wish to represent yourself? Now, do you understand that if you wish to represent yourself, there has to be a written voluntary waiver of the right to counsel? Did you understand?
I do.
All right. And that must be in writing and on the record. Do you understand?
I do.
Has anyone threatened you, coerced you, or promised you anything that would cause you to waive your right to have counsel?
No, but I have a question.
Yes.
So would Mr. Porter be still sitting in my second chair with Mr. McCray being relieved?
Mr. McCray is not being relieved. Mr. McCray and Mr. Porter are co-counsels on this case.
I don't want him on my case, Your Honor. He's moved arbitrarily to my best interest.
Mhm.
He's not filed a single pretrial motion,
Mhm.
which relieves me of any type of pretrial maneuvering ability.
Mhm.
I can't get a fair trial with anything he's done. He's refused to show me my discovery.
Mhm.
He's secreting evidence from me. I don't even know the case,
Mhm.
the state's case in chief about any of it at all, and it's been filed. And he's refusing to cooperate with me on these terms.
Mhm.
Continues to embellish these stories as if I'm being aggressive to him in some way, but not producing anything in lines of the things that I've asked for.
So are you saying you haven't seen a police report?
I have not.
All right. I'm going to continue to go over this. And then if you're saying you haven't seen a police report, I'm sure they'll show you that police
It's not
report
like
right
a
now.
Police report.
No.
it's-
Here's what we're going to do. We're going to answer the questions that I'm asking of you. Do you understand? All right. So back to my question. You've informed the council that you wish to represent yourself. Is that correct?
That's correct.
Now, do you understand that per the indictment, these are, of course, felony charges? Do you understand?
I do.
Do you understand if the state is able to prove up their enhancements? Well, I'm sorry, let me rephrase. For each one of these cases that are in the indictment, the state has to prove each one of those counts beyond a reasonable doubt. Do you understand?
I do.
If the state is able to prove those counts beyond a reasonable doubt, and if they are able to approve the habitual offender enhancement paragraphs, your range of punishments for counts 1, counts 2, counts 3, counts 4 are 25 years to life in prison and up to a $10,000 fine. Do you understand?
I understand.
And do you understand that if they are able to prove the enhancements, there is no eligibility for probation from a jury? Do you understand?
I do.
Have you received and reviewed a copy of the indictment?
No, I have not.
All right. Mr. Ross, I'm going to give you a copy of your indictment.
And it says, according to Article 25.01, that the district clerk is supposed to.
Well, hand that back to me.
Thank you.
Yaya, if you will please give him a copy of his indictment.
Certified
And
copy
let
of the
me-
original.
And excuse me, and let me explain something to you. When you have attorney that is representing you,
He's not.
the attorney will receive that, and the attorney will hand it to you, and that is through the district clerk. But we'll make sure you have that today. All right. Do you understand what you're being charged with in the indictment?
Do understand it.
All right.
But,
Do you understand the
yeah.
elements the state must prove?
I do, and I object to the indictment.
All right. I'm sorry.
I object to the indictment.
All right. But do you understand do you understand all of the elements that the state has to prove?
I do.
Do you understand the full range of punishment with regards to each charge?
It's what you just explained to me.
My question to you is, do you understand the full range of punishment?
25 months.
So for the record, I'm taking that to mean that the defendant does understand. And do you understand you have a right to a jury trial? And if you choose not to have a jury trial, the state will have to agree to a waiver of a jury trial. Do you understand?
I do.
Do you understand that there will be 12 jurors that will be sitting to hear the evidence in this case? And those 12 jurors must come to a unanimous decision if they're able to. Did you understand?
Do.
Do you understand that during jury selection, there are available to you strikes and peremptory challenges?
Do. Or die.
All right, yes. Do you understand if you're not a US citizen, that you will be deported, denied naturalization and reentry? Do you understand?
I do.
All right, then the court will allow the defendant to represent himself. And I'm sorry, after hearing all of the court's questions and answering them, do you still wish to waive your right to counsel?
As in, do I?
Do you still wish to proceed without, I'm sorry, do you still wish to proceed in representing yourself?
I do.
All right, then the court will allow you to proceed to represent yourself. There will be standby counsel. You'll need to sign the waiver. And once you sign the waiver, we will bring the jury in. We'll start with jury selection.
He needs to sign.
Oh, you're gonna send?
I'll sign it. Finish reading it. All right, take this off.
This motion is actually a motion for continuance of 3 days, Your Honor, because I'm completely.
I have not seen the motion.
This is right here. May I make a copy of it and give it to the DA? Because I wrote this by hand.
You'll just need to show it to the prosecutor. No, you don't bring it to me.
The reason for this motion, Your Honor, is that I'm completely unprepared. I have not.
I have not seen the motion.
How do I let you see it? I wrote it here. This is it.
So this is what I'm going to explain to you. When you represent yourself, I am not allowed to tell you how to file motions. I'm not allowed to assist you, because then I become your standby counsel, and I'm neither party's standby counsel. I'm just here to hear any evidence that's presented to me, any motions that are presented to me, and make rulings. That is all.
I would like to bring to the attention of the court that I am under strict abilities that I can't participate like the district attorney does. I don't have access to a computer or a copy machine or any.
Oh, no, here's the thing. It is fine that it's fine that motions are written, but they need to be given to the court in a specific way, and they need to be filed. Now, I am not here to tell you how to file motions. That is something that you need to know how to do, and you need to do.
You know how to do it, Your Honor. But if I was to file this motion, it would come past the time that this jury has been convened, and it would cause a problem with the proceedings of court. So
that's not the way the law works. What you just said.
I don't know how else I'm supposed to file a motion. It's necessary at this moment when I don't have access to any of the basic things.
I just inform you that the court accepts written motions, but as far as my telling you how to do that, that is not what I'm here for. That is for you to decide how to do that in representing yourself.
So, Your Honor, I would like to make a verbal motion. The written copy of it is right here. May I?
And Judge, we would object under the Code of Criminal Procedure.
No, just a minute. It hasn't even been filed or brought before the court yet. And that is something that needs to be done. And so, Mr. Ross, this is what I'm going to tell you again, and I want you to hear me clearly. My role is not to help you with your case. I'm just here to listen to whatever is presented to me. That's it. If I seek to help you with your case, then I'm becoming your standby counsel. And then that means I'm not being objective. So I will not do that. And what I can tell both parties is I will only consider and rule on motions that are properly brought before the court.
I understand. And I would ask for the court to have mercy and understanding there are things that I'm limited to that I don't have access to at all. My hands are tied in this form of being able to.
This is what I'm going to tell you.
It's not fair.
No, this is what I'm going to tell you. And your attorneys will tell you this. My role in this case is not necessarily to have mercy and understanding. My role with regards to this jury trial is to listen to evidence, make legal rulings for motions that are presented before me, and make rulings on any objections that people may have. That is my role right here. I am not sitting. If you were found guilty, the jury would be in charge of your punishment. That's where mercy comes in. That is not with this court at this point in time. My only point is to review documents that are given to me.
Mr. McCray has been communicating with my only witness without my permission or knowledge. And
let me ask you this, and this is the only time I will ask this question. So, is it your belief that attorneys are not allowed to talk to potential witnesses? No, that's my question.
it's not my understanding.
All right, so then I don't understand what you are asking of the court.
To understand an egregious crime that's taking place with obstructing justice from being served in form of interfering with my client. Well, my witness is a veiled threat that she would be arrested if she testified in my case. I need her. She is key to my defense. And he's giving her a veiled threat. And if she testifies for me, she stands a chance of being arrested.
All right, and is this something that you're saying that the witness has informed you?
Yes.
All right, that's what's called hearsay. All right. Anything else?
Reported on conversation, Your Honor.
Anything else?
Yes, I would ask that the court please move to have this man removed from my case.
That's your standby counsel.
My standby counsel is moving arbitrarily to my best interest.
That is your standby counsel. And at this point in time, your standby counsels, Mr. McCray and Mr. Porter, are just that. They are standby. They are not doing any more investigation as it relates to your case. They're just here.
Last night, Your Honor.
Yeah.
He said a meeting with my woman this evening after court.
Yes.
If I can make a record, Your Honor, I've spoken to Tawana Monday any number of times. Tawanya Monday. I've spoken to her any number of times. I would like to think we have a solid enough relationship. I even got her to bring jail clothes to the jail for you. Okay. I've spoken to her numerous times, and yes, I'm meeting with her at 5:30 today on your behalf and to talk to her about her willingness to testify, because yes, according to the state's allegations, it can make the argument that she was your getaway driver. So what I told her was, hey, you might want to consult a lawyer before you testify. I'm bringing her here today so that I will let her know if she needed one, she wouldn't even have to pay. This court would appoint her a lawyer to give her whatever advice and counsel that she needs. And if she got on the stand and pled the fifth, saying that she's not going to say anything because of any possible criminal liability on her part that does not reflect well on you, that's what I communicated to her.
I understand that, but before you even started communicating with her, she was full willing to be my witness.
All right, so stop. This is what I'm going to tell you. Number one, any witnesses that may or may not place themselves in a potential for criminal liability, attorneys are appointed to represent them so that attorneys can guide them on whether or not they should be testifying. And what I can tell you is, in cases, if somebody is charged, hypothetically, if somebody is charged with a criminal case and they want to call, I don't know, their co-defendant, then that co-defendant has a right to have an attorney represent them so that they can help them navigate on whether or not they want to testify and what the potential legal and criminal consequences of that will be. So here's the thing. I'm just here to hear motions. all of this side thing that you're doing, we're not here to hear that.
It's not a side thing, Your Honor. It's crucial to my defense.
Mhm.
Okay.
All right, state.
Judge, I'm in receipt of the defendant's motion for continuance. We would object because one, it is not timely, it is being filed on the day of trial, where the code necessitates that all pretrial motions be filed within 7 days of trial. And further, Judge, I don't believe this is notarized, so it wouldn't be in compliance with the Code of Criminal Procedure for a motion for continuance. Because of that, we respectfully ask the court deny the motion for continuance.
I disagree with this on the grounds of have no way to get, I don't have access to a notary. I presented it to the court the best way I knew how by giving it to the district clerk to present it to the court in this time. The reason for the 3-day continuance that I don't believe would be such a burden on the court proceedings is because I've been kept completely in the dark about all the evidence to do with this case. I don't have any idea of the way or the evidence or the witnesses that the district attorney is planning on using in this case. So therefore, I cannot build a reliable defense against something that I don't know that he has or not. He could just pop up with this mysterious evidence, and I have no clue of it. It's not a fair trial if I don't know what he's got to go against me with, so that I can build my defense against it.
All right, this case has been pending for jury trial since October 9th, 2025. It is now February 3rd, 2026. And so we are proceeding with jury trial. So we're proceeding with jury trial.
I would like to object because I have no clue of the evidence that the district attorney has against me. Mr. McCray has not made me aware of any of the pretrial motions that were filed. And furthermore, he did not produce a single pretrial motion in this case. And he would not communicate with me regarding anything to do with this case. It's just, it is not any way can be considered fair that this ground we stand on for this contest if I don't know the facts of the case.
All right, motion for continuance is denied and the defendant will be fingerprinted. Is there anything else before the jury comes out?
Nothing from the state, Judge.
All right, thank you.
Judge, I'm sorry, I would ask for the timing for the defendant to be fingerprinted. Our fingerprint examiner is here.
Let's do it right now.
Thank you, Judge.
I object to this, Your Honor. What is the reason for the district attorney's fingerprints? I have no clue of this. So I think in order for it to be fair, we have to be brought to speed about what it is that you need these fingerprints for when y'all got 10,000 copies of my fingerprints downstairs.
Okay, so this is what I will tell you. The state filed a motion. They're requesting your fingerprints. The court has granted the motion. So he's going to take your fingerprints. So please remove that objection.
Thank you.
Defense, any opening statements? You may proceed. Yes, you may proceed.
Janice Jones is the owner of Alterations and a gift shop on Desert Valley Road. She's going out of business. A friend of hers approached me because her going out of business.
Judge, respectfully, I'm going to have to object. We're getting into facts that are not yet in evidence. You can say what evidence is going to show, but can't go into testimony.
All right, that objection will be overruled. You may proceed.
Thank you, Judge.
On the day in question, I receive a phone call, or I make a phone call and inquires how to collect on these owed. I was instructed to, or the defendant was instructed to proceed to the shop on Sunday to collect. And they did. But the owner who instructed him to come didn't have the money that she told him to come pick up. Then they left. Then he went to the car, and as he's leaving, he says to his girl, like, can you please go back into the shop and ask this woman how to go about collecting the money that she owes me? She did. She spoke to this woman. This woman said, bring him back at 6 o'clock and I'll pay him then. 6 o'clock, she did not pay. Defendant got upset, cussed her out, and left. On the way home, the defendant and his girls witnessed the police at a high rate of speed going back to where we came from. That's all the defendant knows. There was no intent to this robbery. There was no robbery. There was no weapon. Thank you.
Yes.
Ladies and gentlemen, jury, good morning. I got 20 minutes to do this, and so my life is on the line here, so I would like to I'll break this up into sections for you. Okay. First part, do with aggravated robbery. As she said, aggravated robbery means that you used a gun in the commission of a theft. And I would like to point out that there was no theft. There was not even an intent for theft. As the evidence shows, the defendant went to this shop as instructed to receive pay. Okay. He left the shop, sent someone in to get a better understanding of how he was to collect his money. And she returned with an instruction to bring him back so that he could collect his money. There was never any intent to steal anything. There was nothing stolen on top of that. So the entire inference of a theft taking place doesn't even fit in this category. It was a small piece of money that was sought out to be collected for an enormous amount of work that was done. The defendant was friends with these people. There was no intention whatsoever. There was no weapon found or otherwise. The display that was put on yesterday with the detective, I don't think y'all got to see the detective's interview with the defendant, but what it showed was.
Judge, I'm gonna object to that. That video and that interview, it's not evidence.
All right, the objection will be sustained.
Correct. All right. I'll give you, imagine this. A cell phone and a wallet. Sort of like this is the wallet. And it being behind the cell phone. Can't really put this side on it when I approach,
Yes.
Okay, because this will scratch up the screen of a cell phone. So being that this will scratch up the screen of the cell phone, the flat part is on top of the cell phone. So like holding it like this could be considered. Police have killed people for less than this. A cell phone is a wider grip, but with this on top of it could be considered to be like, it holds a shape of a gun. I can understand that. I can't testify. All right. There was no weapon. There was no intent nor necessity for a weapon. These are people that I worked for that I was going to try to collect monies from. There was no theft. There was no robbery. There was no intent or any type of, that wasn't even an issue. Furthermore, Elisa Ramirez, one of the alleged victims, Daphne also, and Janice Jones, they all knew where the defendant lived. They had all been to the defendant's home. They've interacted in several different ways. It was a lot of stuff done. And so for this to occur, for them not to send the police directly to the defendant's home, but being charged with aggravated robbery just makes no sense. They know where the defendant lived, and they testified to that. I would like to point out the testimony of Daphne, the blonde-haired woman who came up here. So certain people, when you deal with them, they're hard to deal with and they're hard to talk to. And when you approach issues that have a deeper significance to them, and they may try to not let certain parts of that idea come to the light, they would add a manipulative tactic of fear. You're scaring me right now, I can't. You know, and so when you try to, there's no way to approach that without making me seem like an aggressive man. Whereas I'm just trying to get a piece of that information out to share with other people. Okay. So I really feel like I wasn't able to share with you everything that took place because I couldn't fully question her. You know, it's a matter of fairness. Now, that's a manipulative tactic, and it serves to criminalize and place in the minds of people fear because of me. Okay. I look this way. I cannot change it. I wouldn't if I could. God gave this to me. Because it scares someone else the way that I look, I can't do nothing about that. When they act like they're not scared and pretend to be my friend, but really scared of me the whole time, it puts me in a bad position. The way that this society is set up, all somebody got to do is pick up the phone and call 911 and say, hey, this guy did this to me. And 911 is going to rush out there and they're going to arrest this man and they're going to put him in jail, and he got to pay thousands of dollars to get out of jail if he can even pay it. If not, he's forced to, like me, lost everything I had, my home, my pets, my car, my life, a full-time student, a model, an actor. Well, not really, because this little $100 that I was supposed to get from this job.
Judge, I'm going to object to this improper argument. Things are in evidence.
All right, that will be sustained.
Thank you.
Okay. Everything is lost in your life once you go to jail. And all it takes for you to go to jail is for somebody to call and say, hey, I seen this guy do something.
Judge, I'm object to this. This is way outside of anything that was involved in this trial. It's improper argument. It's not in evidence.
All right, that objection will be overruled.
That's all it takes. Certain people in the community know that and use it as a means to control a man, otherwise not in their control, to force him to abide by their will. And this evil, dastardly tactic is something that so many men have fallen to. That's all it takes. 911 call. Have you ever walked into a room and when you walked in, everybody got quiet? Like the air sucked out when you walked in? That happens to me all the time. So I have to be extra careful with the way that I walk, the way that I talk, the way that I interact with people, my level of frustration that may show on my face at any point in time, because it scares people. Now, if that scares people, how am I to live? I suffer emotion just like you do, and you. So when I get upset, if it scares you and someone calls the police and say, this man is a suspect, more back to the point. We heard the 911 calls. Now, the second time the defendant, as testified to, went back to the shop, as testified to by Daphne, as soon as he walked in, he was yelling and loud. You were demanding money walking in the door. That simply makes no sense. How could it be? The defendant was given instruction by way of his girlfriend, as testified to come back to the shop at between 5 and 6 to collect his money. That's the instruction that Janice Jones gave for me. So for her to give me that instruction means that upon our first interaction, she didn't feel threatened. She didn't feel threatened. I didn't threaten her. Upon the first interview with me and Janice, I did get upset when she told me she didn't have my money, because you instructed me to come up here to begin with for that. When she didn't have it, she was saying something to me, and all I heard was like, "Yo, anybody know Charlie Brown? Raise your hand if you know Charlie Brown." Everybody heard of Charlie Brown? You know, Charlie Brown's mom used to, when she was talking to him, go, whoa, 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 whoa. This is all I heard. And I was like, let me get out of here. Baby, can you go tell her?
10 minutes.
Can you go ask her what she want me to do to get my money? And so she did. And she did. And I came back to get my money. So there was no yelling and arguing. There was no, none of that. Now, upon her telling me again that she didn't have my money, yes, I had a bad reaction, as we all are humans are capable of. And in this situation, I've learned what I already knew over again. Control yourself at all times. I let this get to me because I had plans for this money, and what I did was verbally, what was like a, what the, and that was enough to seeing her diving for cover and this other one hiding behind the chair. I'm like, what y'all jumping for? Like, whatever, man. Look, give me my money, man. Why you keep playing with me? With my phone in my hand and my wallet. Didn't I work for her? Didn't I do everything she asked me to do? This is how you do me? I respect my elders. I protect my elders, and I was taught better than to raise my voice at my elders. And I let this situation get away from me because I felt played. I was impressed by this woman's shop. Let me get back to this thing before I run out of time. Okay, as to the crimes. As to the crimes. So for aggravated robbery, it got to be a gun. It got to be a theft. Even though the theft didn't have to take place, it had to be an attempt at a theft. None of these are the case. They made it clear that one, nothing was stolen, and just two, we heard the phone calls. We know that the defendant's entire intention was to go and collect money that was owed to him. Everybody knew it's clear that if there was money owed to him. The work that he did, the money that, on top of the money that was owed to him, after the interview with the detective, she paid. She paid him this money that he went to collect. All of this for that. Had she given the defendant the money when he went to collect it, there would have been none of this. But after it's all done and said, and the police are involved and lives are on the line, now you pay? It's some laudable fixture of what you created? This is the result of it. Only I have to suffer. there's no theft at all. There was no assault for Daphne or Elisa because there was no pointing the gun at them. When I was talking to them in that heated moment that was recorded by the 911 call, my phone in my hand, talking like this. Why you keep playing with me? Like, what? Didn't I work? Didn't I operate in good faith? Didn't I work for free 4 days? At the end of the second day of work, I asked for a portion of my pay. Not the entire thing, because I know she said that we aren't gonna get paid till the end of the job. I said, can I have 20 bucks? Get a little something to eat tonight and have gas money to make it back tomorrow so I can complete this job for you. That's my entire pay. So that's all it took. Another man that was there gave me $20 as testified to. But at that point, I felt like her whole intention was to get this work out of me and not pay me in the end. So I was like, if you don't give me anything, if you don't give me anything at all, I'm not coming back to work for you anymore. She took that as a threat. I took that as a sign of
5 minutes.
I took that as a sign of what could possibly be coming from this thing. I worked for you for 2 days in good faith, not getting any money. Asked you for a portion of my pay so that I could come back and continue working for you. And you're not even willing to give it to me. Took the whole attitude, became angry with me. I'm like, you know what? You're trying to get over on me. You know what? Keep it. All that you can keep. I'll get it later or whatever. I'm not coming back up here to work for you again. And I did. I did everything I could to stay away from going back up to the shop. Only reason I went up there is because she instructed me to. That being the case, there's no theft. There was no attempted theft. There was no gun as they testified to. But you know, do any of y'all are any of y'all aware of Breaking Bad? It's a series on AMC. Okay, it's a scene in Breaking Bad, and I gotta kind of hurry up and wrap it up. But this scene in Breaking Bad, this dude is in his house and he's smoking drugs. Okay, and outside of his window, he sees Jehovah's Witnesses, you know, on their bikes. Okay, they come into his house and to push the doorbell. Right, as they doing this, the drugs kick in. Boom. And when the drugs kick in, all of a sudden, this looked like biker gang pulling up on him. He's like, oh no, you know, and then so he runs and hides in the closet and like, because it's a big biker gang outside, and these little skinny dudes, Jehovah Witnesses with their helmet on for their bikes, and like, hey, so this whole inference that everyone's given that testified about me coming in here as this big bad man is doing all this hollering and screaming, demanding money is just not true. That's not the way it went. It's not the way it worked. That's not how I even operated. I had permission to be where I was at. I was in fact invited twice for the purpose of collecting monies owed. There was no intent to steal anything. There was no weapon. There was no weapon found. There's no crime here except them being mad at me because I left them to have to pay someone else to do the work that I would have done. And I guarantee you they did not do as a good job. So they're going to show me, I'm going to show him by putting me in this position. I couldn't understand it myself, but then I found in my mind that that's the only thing it could be. When I refused to come back and work for you, now a woman's held no fury like a woman scorned. Now you gotta go find somebody else to try to get the quality of work that I was giving you. It's difficult. I work hard. Defense rests, Your Honor. Thank y'all.
All right, State, you have 16 minutes.
Thank you, Judge. Ladies and gentlemen, it's been a long week. And unfortunately, my friends, this is the hard part. This is when y'all have all the odds in front of you, all the testimony, everything that we have, and now it's time for y'all to make the call. If y'all remember in jury selection, when I was talking to y'all about guilt, innocence, what we're talking about right now, basically the question, did he do it? Did I do my job? Did I prove to y'all beyond a reasonable doubt that Mr. Ross over there committed all these counts? And the answer is yes. Let me take y'all through why. Let's see. Count one. On June 1st, 2025, James Ross, while in the course of committing theft of property and with the intent to obtain and maintain control of said property, intentionally knowingly threatened and placed Janice Jones in fear of imminent bodily injury and death, and the defendant used or exhibited a deadly weapon, to wit, a firearm. There's another wrinkle there where it's robbery now. You know what the difference is between aggravated robbery and robbery? That. So the facts. This isn't TV shows. This is real life. This is what y'all heard. This is what was directly in front of y'all. Janice Jones' testimony. Terms of the employment were clear. No payment until the job was done. Mr. Ross did not complete the job, and he wasn't going to wait for the job to be done. Even though he was told everyone gets paid when the job's finished, he wanted his money now. 911 call, where it's confirmed from the defense's own witness that that's his voice. I'm not waiting for you to get it finished. In order to get his money that he did not have a right to because he did not complete the job and it was not time for payment, he threatened Janice Jones. Give me my fucking money. I know where your store's at. I know where you live. Does anyone here think that that is not a threat against her? To say, I know where you are. I know where you sleep at night. Maybe I'll come pay you a visit. That's a mob threat if I've ever heard one. Janice testified.
Sustained.
Janice testified that she saw James Ross pull a silver gun, wave it around, and point it at Dawn and Alyssa before putting the gun under her throats. Now, defense is trying to say that this is all a plot by Ms. Jones and these two other women to squirrel him out of that money. He says that Ms. Jones is a vindictive, manipulative person. Listen to her talking on 911 call number 2. Does she sound like she's being angry? Does she sound like, you saw her up there. Does she sound like she was being manipulative? Does she seem like someone who would lose it on somebody? There's only one person losing it on that 911 call. Count number 2. On or about June 1st, 2025, James Ross did intentionally and recklessly threaten imminent bodily injury and death to Alyssa Ramirez by pointing a deadly weapon at and in the direction of the complainant, and the defendant used or exhibited a deadly weapon, to wit, a firearm. How do we prove this up to you? Alyssa's testimony. In terms of employment were clear. No payment until the job was done. Same as Janice. James did not complete the job, and he wasn't going to wait for the job to be done. He wanted his money now. He came in that day. She hid behind a chair, and we can hear her. We can hear her on the 911 call number 2. That's her 911 call, where she called 911. She sounded her phone as she testified to, and we can hear the whole thing in real time as it's happening. Alyssa testified she's hid behind a chair. And when James Ross saw her, he pulled the chair away and pointed a gun down at her. She described the gun not as a silver gun, but as a dark gray revolver. Gray and silver. As I said in jury selection, I want y'all to think. I want y'all to use common sense. Are gray and silver pretty close? And number 3. On June 1st, 2025, James Ross did intentionally know and recklessly threaten imminent bodily injury and death to Daphne Smith by pointing a deadly weapon at in the direction of the complainant, and the defendant used a deadly or exhibited a deadly weapon, to wit, a firearm. The facts. Testimony by Dawn, by Daphne Smith. Again, the terms of employment were clear. No payment until the job's done. James Ross did not wait. He wanted his money now. Daphne testified that James Ross, when he came in, picked her up by her sports bra and threw her against the wall. That testimony is backed up by Alyssa, and by Janice. They all said he came in and did the same thing to Daphne. Daphne described the gun as silver and the shape of an L. Remember, she was up there and she was doing, it was in this shape, not this little shape like this here. She did not describe it as just one little spot. She described it in the shape of an L. Y'all remember? That does not jive with the defense's theory. Daphne said that she saw James Ross. She demonstrated for y'all that he pulled it from the front of his shorts. He didn't pull it from his sock. He didn't pull it from the back of his pants. He pulled it from the front. Use your common sense. Do people keep their wallets up in the front of their shorts? Or do they put another object there? Daphne testified that she saw James Ross put the gun to her head. She said she felt threatened. She felt that James Ross was going to kill her. Y'all heard her say to his face, "You know what you did that day." Now, 4. On or about June 1st, 2025, James Ross, having been convicted of a felony offense, intentionally, knowingly, and recklessly possessed a firearm after the 5th anniversary of the defense release from confinement, and the defendant's possession occurred at a location on the premises at which the defendant lived. State exhibit number 2. Case number 9666641D, State of Texas versus James Ross. Convicted. Aggravated assault with a deadly weapon, to wit, a firearm. This is going back with y'all. The place where he possessed it at, JC's alterations. Place where he did not live.
What is your objection?
Make it seem like the gun that I had was used at that scene.
All right.
I was supposed to be able to use the inference that that justifies this.
All right, the objection will be overruled. You may continue.
Thank you, Judge. James Ross was convicted right there, State Exhibit 2, of aggravated assault with a deadly weapon. James Ross possessed a weapon by having a gun in his hand. That's the testimony of Janice, of Alyssa, and of Daphne. He possessed that firearm after the 5th anniversary from his release from confinement. That's in the judgment right there. And he possessed it at a place where he did not live, JC's alterations at 4427 Days of Bala Road. Now let's get to this. Detective Vasquez testified that a silver wallet could be seen as a gun. Former law enforcement officer, I respect that. I respect his opinion. And he's right. It could be seen as a gun, no doubt or question. But could is just possible. What's the difference between possible and probable? It's possible that I could win the lotto tonight. It's possible that we could all win the lotto tonight. But is it probable? I haven't won yet. Let me ask you, what are the odds that one person mistakes a wallet for a gun? It's possible. It's possible that one person can make a mistake. I'll even concede there was Janice made the wrong call, just like we talked about with the detectives about she said she had the wrong identification of James Ross. It's possible for a person to make a mistake. They went back and she was able to pick him out of not just one picture, but 6 pictures and say, that's the guy. Let me ask you, what about 2 people? Can 2 people mistake a wallet for a gun? That's starting to get unlikely. But 3 people, all in the same room, all looking at the same object in the same moment, in the same instance, can 3 people look at a silver wallet and think it's a gun? Now we're getting into extremely unlikely territory. 3 people say that James Ross pulled a gun. 3 people up there testified to y'all that it was a gun. The demonstrative was never shown to any of the witnesses. They were never able to say, that is not the object that I saw that day. 3 911 calls, all saying he had a gun. Gun, at gunpoint, he had a gun. No one was talking about the silver wallet until the defendant brought it up in his interview. Let's talk about the defense's witness, Twania. So she testified first that yesterday to y'all, that she did not see James Ross with his wallet when he went into alterations. After I pressed her a little more, her story changed up to, yes, I saw him with his wallet. It was in his hand when he was going inside. So it went from, I didn't see anything to, oh no, wait, yeah, I did see it once I started pressing her. She testified that James Ross is known to have his wallet in his pants or in his socks. She testified that she did not know if he had it in the front of his shorts, the place where Daphne said Mr. Ross pulled the so-called silver wallet. Let me ask y'all, as I said, and as I told y'all the whole time, I want y'all to think, which one of these scenarios is more reasonable?
5 minutes.
Thank you, Judge. Scenario number one, James Ross has faked this whole thing. He knew that when he went in there, he better not have a gun. There we go. He knew that when he went in there, he better not have a gun because he's a convicted felon. So he concocted this amazing scheme where he's going to go in, he's going to wave around his silver wallet and just pray to God that 3 people in a well-lit room with this object close to their face in broad daylight are just going to mistake it for a gun. Or scenario number 2, he had a gun and he threatened Janice and Alyssa and Daphne that day. But then he gets word from Detective Alvarez that, hey, we need you to come in. So it's like, oh, I need to come up with something. Maybe if I use my silver wallet, I can swing the detective, be like, yeah, I didn't pull out a gun. I just pulled out my wallet. There was no gun there. There was nothing going on. Perhaps they mistook this for a gun. All this while texting Janice. Call up the cops. Ag Rob starts at 40 years. He didn't get arrested that day. And like Daphne said, he knew what he did that day. So he had time to concoct this story so that he can try and swing this with the detective and see if he can throw him off the trail. So let me ask you, those 2 scenarios, it's all about proof beyond a reasonable doubt. Which one is reasonable? Which one is unreasonable? Y'all remember this? Circumstantial evidence. I don't have the boulder here. All I've got is the gravel. Let's go over the gravel. 3 witnesses, all with very similar stories about James Ross and a gun. 3 911 calls, all talking about gun at gunpoints. James Ross was seen pulling a gun from his front waistband, not from his back pocket, not from his socks, his front waistband. Twania changed her story. Twania said that he doesn't keep his wallet, the object that he allegedly used to fake this in his front waistband.
Misrepresentation.
All right.
From the witness's testimony yesterday.
All right, ladies and gentlemen, you remember the testimony as you received it.
The coup de grace. Detective Alvarez tells James Ross, hey, I'm doing this courtesy call. If you got a warrant, I'm going to tell you need to come in. When James Ross gets that call, guess what? He never comes in. Breaking another promise. He said he'd work the whole week, and he didn't. He said he would come in, and he didn't. He never did. I'll have all the pieces in front of you. Now it's time for y'all to make the call. Can y'all see the picture that is in the puzzle, even with spots missing? The answer is yes. Y'all have what you need. Y'all have proof beyond a reasonable doubt. Because of that, I'm going to ask you to do this. This is a copy of the packet y'all are gonna go back with. Count one, aggravated robbery. We, the jury, find the defendant James Ross guilty. Sign right there. If y'all don't believe me, and y'all think a gun was not involved, he did all this in the course of committing theft. And as Judge said, course of committing theft is the conduct occurs in an attempt, not completion, attempt to commit during the commission or in immediate flight after the attempt or commission of theft. Defendant is trying to say he didn't steal anything, so there was no robbery. As Detective Landrum said right up there, if you walk into a bank with a gun demanding cash with a bag in your hand and they lock the doors and close the windows and you walk out with nothing, does that mean no harm, no foul? Does that mean, hey, you didn't get anything, so
Time.
good to go? Ladies and gentlemen, this case has been proved to you beyond a reasonable doubt.
All right, that's overruled. Time, counsel.
Thank you, Judge.
Thank
We
you.
ask that you come back with a verdict of guilty. Thank you.
All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct? And is that verdict unanimous in each count? All right, if you'll hand the verdict form to Deputy Laura, please. Thank you. All right, if the defendant will please rise. Count one, it states, we, the jury, find the defendant James Ross not guilty of the offense of aggravated robbery as charged in count one of the indictment. Count one, lesser included offense of robbery. It states, we, the jury, find the defendant James Ross not guilty of the lesser included offense of robbery under count one. Count two, it states, we, the jury, find the defendant James Ross not guilty of the offense of aggravated assault with a deadly weapon as charged in count two of the indictment. Count three states, we, the jury, find the defendant James Ross not guilty of the offense of aggravated assault with a deadly weapon as charged in count three of the indictment. Count four reads, we, the jury, find the defendant James Ross not guilty of the offense of unlawful possession of a firearm as charged in count four of the indictment. Does anyone wish to have the jury polled? All right, everyone, please be seated. All right, ladies and gentlemen, the deputy will take you back to the jury room and I'll come back and speak with you briefly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Ross, if you would like to have a conversation with your standby counsel will explain to you about expunctions. And you have 30 days to present that to the court. Is there anything else from either party before we close the record? All right. All right.